Thank you very much, Mark. Thank you. So this session, Judicial Independence and Parliamentary Sovereignty, a colossi of roads. I'm sure our speakers are not going to quite see it that way, but there has always been and will always be, I think, a dynamic between politicians and the judiciary, and we'll explore that today. So ministers, chief justices, judges, honoured guests and delegates, welcome to this plenary session. First, may I thank our hosts, the Government of Malta and its people sitting at the crossroads of the Mediterranean with a rich and ancient history, who have greeted us with warm Maltese hospitality. May I also thank the CLA and the Secretariat for organising this unique and wonderful event and for giving me the opportunity to moderate this very important discussion with a most distinguished panel. I've attended this conference as a council member for many years, and may I say, to me, it is unique in bringing together the diversity that is the strength of the Commonwealth of Nations with all pillars of the Constitution represented. 3 years ago, The Guardian reported the Supreme Court taking positions more palatable to government as top MPs attack judges, notes cross-party report. One MP had suggested in the United Kingdom that the role of Lord Chancellor had become a political stepping stone from which to take pot shots at the judiciary. Is this a creeping attitude of parliaments throughout the Commonwealth? And is it a step too far beyond the Latimer House Principles? The Latimer House Principles, formerly known as the Commonwealth Principles on the three branches of government, are a set of guidelines adopted by the Commonwealth countries to promote good governance, democracy, and the rule of law. Those principles were endorsed by the Commonwealth heads of government in 2003 and later confirmed in the Commonwealth Charter. This led to the development with the CLA of the Commonwealth Latimer House Principles Toolkit on separation of powers, which was developed in close cooperation with the Latimer House Working Group. The toolkit sets out clear steps to ensure that the principles are implemented. And those Latimer House principles we well know are separation of powers, judicial independence, transparency and accountability, respect for human rights, representative and inclusive governance, legislative oversight. The subject for discussion, those principles, today comes at a time when both the foundations of parliamentary democracy and the rule of law are under existential threat. We've seen most recently lawyers face a wide-scale attack, not for their own views on politics, but for whom they act. The subject is close to my heart as both co-chair of the CLA Human Rights and Rule of Law Committee, but also as a practitioner, having represented those parties in both the Brexit-related constitutional cases in the UK, for which we were physically threatened and castigated. The judiciary at first instance were headlined, enemies of the people. Those lawyers representing migrants in the UK faced constant threat. When I was president of the Law Society, we had to remonstrate with politicians to stop the attacks on immigration lawyers. But they continue even against immigration judges. The subject is sadly ever more prescient. We're honoured to have a panel today that is at the heart of the dynamic between politicians, both in Parliament and the Executive and the Judiciary. Our speakers today are firstly the Right Honourable Baroness Carr of Bolton-on-the-Hill, who served as Lady Chief Justice of England and Wales since 1st October 2023. Baroness Carr was called to the bar in 1987 and practiced from 4 New Square Chambers, just around the corner from our own offices, in the field of professional negligence. She was appointed QC in 2003. On 14th June 2013, Carr was appointed a High Court judge sitting in Queen's Bench Division. She was assigned as a member of the board of the Judicial College from 2014 to 2018 and served as a member of the Investigatory Powers Tribunal from 2014 to 2016. She is the first woman to serve as head of the Judiciary of England and Wales since the inception of the office of Lord Chief Justice in the 13th century. She previously served as a High Court judge from 2020 and Lady Justice of Appeal to 2023. Baroness Carr has chosen to be styled Lady Chief Justice and of course succeeded Lord Burnett, who is well known to the CLA, on 1st October. The Right Honourable Tengku Mamun is a Malaysian lawyer who has served as the 10th Chief Justice of Malaysia since May 2019. She's also the first woman to ascend to the highest judicial office of Malaysia. CJ Mamun joined the judicial service in 1982 after a career that including postings at the Attorney General's chambers, magistrates and session courts. She was appointed a judicial commissioner in 2006. Between 2007 and January 2013, she served as a High Court judge, and prior to her appointment as a judge of the Federal Court of Malaysia, she was elevated as a judge to the Court of Appeal of Malaysia. She served in that position for 6 years. She enjoys a number of honours from the Malaysian government, Grand Commander of the Order of the Loyalty to the Crown of Malaysia, Commander of the Order of the Defender of the Realm. The Right Honourable Marlene Malahoo, an old friend, if I might put it that way, of the Commonwealth Lawyers Association, is a Jamaican politician. And interesting in the dynamic, she will be giving the politician's view on the subject. She was a working lawyer and a resident magistrate before being elected to the House of Representatives as MP for St James West Central in March 2016 after the Jamaican Labour Party won the 2016 general election. She served as a senator for Jamaica Labour Party and served as a state minister for foreign affairs and foreign trade from 2009 to 2012. She's been Minister of Legal Constitutional Affairs since January 22 and was the Attorney General of Jamaica from March 2016 to January 22. Finally, and certainly not least, Margaret Satterthwaite. Margaret is an American legal scholar serving as a special rapporteur on the independence of judges and lawyers for the United Nations. She's a professor of clinical law at New York University School of Law, where she heads the Global Justice Clinic. She became faculty director of the Robert and Helen Bernstein Institute for Human Rights in 2015. She led the Center for Human Rights and Global Justice starting in 2006. In October 22, she was appointed as United Nations Special Rapporteur on the independence of judges and lawyers by the Human Rights Council. And that's a position that's existed since 1994. It might be said that Margaret has commented on certain developments in the UK in relation to the Rwanda or the proposed Rwandan deportations. This is a plenary session. We are going to take questions and observations. I would ask that if there are observations, they're kept fairly short, but we will do that as soon as we've finished our speaking elements. So I'm going to call on Baroness Carr to step up to the podium.
Well, good morning, President, Chair, fellow panellists, and colleagues. What a pleasure to have been asked to take part in this panel today at this, the 24th Biennial Commonwealth Law Conference, and my first, and to be here in Malta. Malta is, of course, well known to the judiciary in England and Wales, not least because one of my recent greatly respected predecessors, Lord Judge, was born here. And I come with many good wishes, not only from my English and Welsh colleagues here today, but also from those back in England and Wales, including John McKendrick, a former member of your executive committee, who I look forward to swearing in as a High Court judge next Tuesday. Well, we have had a warm-up for today's session, haven't we, with an excellent panel chaired by Marlene yesterday on Parliament and the judiciary. What is the proper relationship? I sat there spellbound thinking, welcome to my world. But I want to start today by recalling what is said at the very outset of the Latimer House Principles on the three branches of government, having articulated that each of the three branches, Parliament, executives and judiciaries, are the guarantors of the rule of law. It sets out the principled approach that ought to guide relations between Parliament and the judiciary, and it states this: relations between Parliament and the judiciary should be governed by respect for Parliament's primary responsibility for lawmaking on the one hand, and for the judiciary's responsibility for the interpretation and application of the law on the other hand. Judiciaries and parliaments should fulfill their respective but critical roles in the promotion of the rule of law in a complementary and constructive manner. And it then goes on in the next principle to affirm judicial independence as itself integral to upholding the rule of law. The principles, of course, as David has said, build on the 1998 guidelines for the Commonwealth on parliamentary sovereignty and judicial independence. The essence of both the guidelines and the principle is, as the Supreme Court's decision in the Miller case in 2017 demonstrates, a central feature of the United Kingdom's uncodified constitution. For those of you not familiar with the decision, the Supreme Court there emphasised how both parliamentary sovereignty and judicial independence were central features of the Constitution. That they are so independent reflects what Lord Bridge once described as the twin foundations of the UK's commitment to the rule of law: sovereignty of the King in Parliament in making the law, and the sovereignty of the King's courts in interpreting and applying the law. Just as the Colossus of Rhodes would not have stood for very long without both his legs intact, without both Parliament and the judiciary carrying out their constitutional roles effectively, the rule of law, I suggest, would not also stand for very long. The second of the Latimer House principles goes further than this, though. It also emphasises the need for there to be mutual respect between the institutions of government. This is also something that has often been stressed by the courts. Nolan LJ put the point in this way in M against the Home Office in 1992, commenting on the relationship between courts and government. The proper constitutional relationship of the executive with the courts is that the courts will respect all acts of the executive within its lawful province, and that the executive will respect all decisions of the courts as to what its lawful province is. More recently, the House of Lords put it this way: in the field of constitutional law, the delicate balance between the various institutions whose sound and lasting quality is maintained to a large degree by the mutual respect which each institution has for the other. And more recently still, the Supreme Court has stressed the importance of the fact that courts and legislature each have their own particular role to play in our Constitution, and that each must be careful to respect the sphere of action of the other. Mutual respect requires judiciaries to ensure that they do not seek to subvert Parliament's legislative prerogatives. That is one reason why the common law is developed cautiously and in a principled way, moving from precedent to precedent, subject to Parliament's power to revise and, if necessary, correct common law developments. It's one reason why the courts are required to give effect to parliamentary accountability, that is, to ensure that the executive give effect to the laws enacted by Parliament and to ensure that Parliament is able to carry out its constitutional functions. It also underpins the requirement that judges do not engage in matters of politics whilst in office. Mutual respect also requires the executive and legislatures not to subvert the judiciary's role in adjudication. No bill of attainder through which Parliament could declare individuals or groups within society to be guilty of crimes has, for example, been enacted since 1798. Mutual respect also underpins what is now reflected in the statutory duty placed on government ministers to ensure that they and civil servants do not use their ability to gain access to the judiciary to seek to influence decision-making. On the contrary, those with responsibility for the judiciary or the administration of justice, such as His Majesty's Courts and Tribunal Service, are required to uphold judicial independence. Mutual respect also, I suggest, calls on the institutions of government to be careful in how they treat each other. We have a convention that the executive does not criticise judges' ability, their character, or their motives. This is rooted in the separation of powers and the independence of the judiciary. It is part and parcel of the convention that precludes judges from criticising extrajudicially the executive, commenting on government policy, or speaking critically of the legislation which it is then their constitutional role to interpret. Both aspects of the convention exist to promote the rule of law. Abuse ought never to be an acceptable approach for any institution of government to take to another. This is, of course, not to say that the public at large and politicians are not entitled to debate or express disagreement with judicial decisions, provided always that the judicial function and result are respected. Far from it. Scrutiny and reasoned criticism are an integral and important part of open justice, the rule of law, and the sign of a healthy, functioning democracy. The outcome of individual cases, the balance to be struck between individual rights, can be debated vigorously. But such debate must be based on fact, not misconception. It is one thing to disagree with a judgment, to disagree with a law, to campaign to change it. But it is another thing to misstate what was said in a judgment or to misstate the law. I stress in saying this that this is not special pleading on the part of judiciaries. As I've said, democratic accountability of the judiciary stems from robust and public debate and discussion of their judgments. But inaccurate or unfair criticism tends to erode institutions, public confidence in them, and the rule of law. The abuse of one institution of government runs the risk that each institution will, in turn, be weakened. A key part of fostering the respect to which I have referred is to take steps to develop the understanding of the other branches and society at large about the proper role and the work of the judiciary. In my own jurisdiction, it is one of my regular functions to provide an annual report to Parliament on the work of the judiciary, covering the wide variety of activity taking place both inside and outside the courtroom. I and some of my senior colleagues will also give annual appearances to the two parliamentary committees concerned with justice and the Constitution. This engagement is an important and welcome opportunity, allowing me to make public remarks, give evidence about the state of the justice system, and to answer any questions that the committees may have for me. This is usually followed by an annual press conference, which again allows for the public, members of the press, and legal publications to ask me the questions that they have. All of this is a part of my wider drive to offer greater transparency on the work of the courts so that understanding across society may be increased. Part of this has been my appointment of a number of parliamentary liaison judges, including Lord Justice Dingemans, from whom you heard yesterday. The role of this group being to engage with parliamentary staff and also members of Parliament, particularly when they arrive new. We are developing and championing a court and tribunal visits programme which sees judges and tribunal members inviting their local MPs to visit their constituency court and tribunal centres. I'm quite sure that other jurisdictions too will have developed their own methods for engagement, and I'm interested in hearing on how those other methods may operate and the success and outcomes they may have achieved. The spirit of the Latimer House principles was, it seems to me, to emphasise the importance that Commonwealth countries place on the enhancing of mutual respect, on comity between each of the institutions of government to better secure the rule of law. It is more than 20 years since the Latimer House principles were issued, just under 20 years since the Edinburgh Action Plan was issued. Is it perhaps time to consider the development of a new action plan, one that builds on the principles and which seeks to devise guidance on how we can all look to develop and promote mutual respect and comity, and in that way further promote the rule of law? I wonder what you think. Thank you very much indeed.
Mr. Timothy Rue, President of the Commonwealth Lawyers Association, esteemed panelists, distinguished guests, delegates, ladies and gentlemen, Assalamualaikum, peace be upon you and a very good morning. Allow me to begin by sincerely thanking the Commonwealth Lawyers Association, CLA, for inviting me to share Malaysia's perspective on the topic. And I would also like to take this opportunity to commend the CLA for the outstanding efforts in organizing this biennial conference. In most jurisdictions, including many Commonwealth jurisdictions such as Malaysia, judges are appointed and not elected. And this is for good reason, in that justice is beyond the political process. An independent judiciary exists for the primary purpose of doing justice, unimpeded by any external or internal factors that do not concern the law and the facts. The judiciary is motivated only by the need to uphold the rule of law. Elections, on the other hand, are of central importance in any democracy, as each elected representative carries with him or her the will and mandate of the people. Judges and elected representatives separately comprise two sides of the same coin, which is that both sides exist to serve the people in different capacities. A nation cannot function without each of these, primarily the legislature, from which the executive branch also draws its mandate. But like a marriage where both a husband and wife comprise a single marital unit, there are bound to be tensions between the two. And like how tensions between a husband and wife can cause tensions in the family, the inherent tension between that sometimes exists between the legislature and the judiciary can lead to severe repercussions to the nation. The essence of the Federal Constitution in Malaysia is enshrined in Article 4, Clause 1, which states that the Federal Constitution is the supreme law of the Federation of Malaysia, and any law passed after Independence Day, which is inconsistent with the Federal Constitution, shall, to the extent of the inconsistency, be void. The significance of Article 4, Clause 1 lies in its two distinct limbs. The first limb expressly declares that the Federal Constitution is supreme, establishing beyond doubt that Malaysia is a nation governed by constitutional supremacy rather than parliamentary sovereignty. Constitutional supremacy in Malaysia is enforced through the second limb of Article 4, Clause 1, which provides for any law that falls outside the purview of the Federal Constitution to be declared void. Essentially, prior to 1988, Article 121, Clause 1 of the Federal Constitution specifically stipulates the vesting of the judicial power of the Federation in the superior courts. Around that time, before 1988, reports were rife that the then government was unhappy with the fact that the judiciary was making decisions that invalidated decisions of that government. A crisis unfolded when several key judicial decisions were perceived as unfavorable to the government of the day. In other words, the government felt pressure from a judiciary that was doing its job. The then Prime Minister mobilized a constitutionally appointed tribunal to remove the then Lord President, equivalent to the Chief Justice presently, Tun Salleh Abbas. Parliament then passed a law in 1988 amending Article 121, Clause 1 of the Federal Constitution to remove any vesting of the judicial power in the superior courts. By that amendment, the jurisdiction of superior courts shall only be to the extent as determined by laws passed by Parliament. In a decision known as Kok Wah Kwan, the majority of the Federal Court held that the 1988 amendment to Article 121, Clause 1 effectively watered down the judicial power of the superior courts. Thus, in Malaysia, we too have seen our share of unconstitutional incursions into the judiciary spurred by tense relationships between the legislature and the executive on the one side and the judiciary on the other. Since 1988, the judiciary has been blighted by views that it has lost its independence, its vigor, and perhaps even its legal or moral authority to decide cases, and there have been a few scandals that followed the sordid events of 1988. Currently, the Malaysian judiciary has reclaimed its independence and has restored itself as an independent defender of the Federal Constitution. And this began sometime in 2017 with the trilogy of cases known as Semenyih Jaya, Indira Gandhi, and Al-Manudo. These cases departed from Kok Wah Kwan, where they held that when reading the amended Article 121, Clause 1, in light of Article 4, Clause 1, judicial power remains vested in the courts, and such power cannot be whittled away by constitutional amendment. Legal reform takes time. Even after the trilogy of cases, the judiciary had to slowly move away from English principles of administrative law that are not entirely applicable in Malaysia, because in Malaysia, Parliament is not supreme. Recognizing this, and in line with the trilogy of cases, the Federal Court in two landmark rulings shifted away from the old English approach by declaring that ouster clauses are legally invalid and unconstitutional. The power of the courts to invalidate ouster clauses does not in any way give rise to judicial supremacy or judicial activism. The exercise of a judicial power to strike down legislation, even legislation that seeks to make amendments inimical to the Federal Constitution, is a fundamental aspect of the Federal Constitution itself. The judiciary, like the other branches of government, remains subject to the Federal Constitution. The doctrine of separation of powers ensures that it does not encroach upon the functions and duties of its co-equal branches. A fundamental safeguard, judicial independence is of course a core tenet of the Federal Constitution, and a fundamental safeguard of judicial independence lies in the process governing judicial appointments. The Federal Constitution sets out the process of consultation among the Prime Minister, the top judges, the King, and the Conference of Rulers before any judicial appointment is made. This constitutional framework was further bolstered by the Judicial Appointments Commission, which was established under the Judicial Appointments Commission Act 2009. While appointments ultimately remain a prerogative exercised by the Prime Minister within the constitutional structure, the Judicial Appointments Commission plays a pivotal role in identifying and assessing candidates through a structured and rigorous evaluation process, including assessing integrity, competence, experience, and industriousness, ensuring that only the most qualified individuals are selected for judicial office. There have been proposals to amend the Judicial Appointments Commission Act and the Federal Constitution to remove the role of the Prime Minister in the appointment of judges. Such amendments, in my view, would ensure that judicial appointments are free from any perception of political influence. There are other express provisions in the Federal Constitution to safeguard judicial independence, such as the security of tenure, financial security, power to punish for contempt any person who interferes with the administration of justice or undermines the dignity and independence of the courts, and restriction against discussion on the conduct of judges in Parliament. Beyond its express provisions, the Federal Constitution also embodies implied protections for judicial appointment. This principle was affirmed by the Federal Court in a case called Haris Fatila, which considered whether criminal investigative bodies can investigate serving Superior Court judges. The Federal Court held that while Superior Court judges are not immune from criminal investigations, such inquiries must adhere to a higher standard to safeguard judicial independence. While constitutional safeguards provide a strong foundation for judicial independence, history such as the 1988 crisis and other scandals have shown that institutional protections are not always sufficient to shield the judiciary from external pressures. The resulting friction from the executive and the judiciary in Malaysia culminated in the removal of the then Lord President and the suspension of 5 Supreme Court judges, 2 of whom were later dismissed. The 1988 crisis dealt a severe blow to judicial independence and public confidence in the judiciary. It cast a long shadow over the institution, fueling concerns about political interference in judicial affairs. The process of restoring the judiciary's credibility required more than institutional reforms. It demanded a steadfast commitment to rebuilding trust, both within the legal community and among the public at large. Through perseverance and collective efforts, the Malaysian judiciary has reaffirmed its standing as a truly independent institution. And this effort is not the judiciary's alone, but from all stakeholders involved in the administration of justice. Support from the Bar Council strengthens judicial resolve and bolsters judicial independence. And in this regard, I would like to express my heartfelt gratitude to the Commonwealth Lawyers Association for its statement dated 19 March 2025, calling on all parties to uphold judicial independence and to specifically respect the process of judicial appointments. In closing, the Malaysian system is founded not on parliamentary sovereignty, but on constitutional supremacy. At all times, the Federal Constitution stands as the highest authority, establishing the framework within which all branches of government must operate. No single branch is supreme in its own right. Rather, each derives its legitimacy and powers from the Federal Constitution itself. Within this framework, the unequivocal role of the judiciary is to uphold the supremacy of the Federal Constitution by ensuring that parliamentary and executive power remain within their constitutional limits. This duty demands that judges adjudicate cases with absolute independence, impartiality, and integrity without yielding to fear or favor. At the same time, a constructive and balanced relationship between the judiciary and the other branches of government is essential to preserving judicial independence while respecting the democratic mandate of Parliament. This relationship is not a contest for supremacy, but a partnership in governance, one founded not just on mutual respect, but on clear understanding of our respective roles. Thank you.
Good morning. Ministers, Chief Justices, Mr. President, honorable judges, and esteemed colleagues. It's a true honor to be here with you today. And I wish to start by extending my thanks to the organizers of this august meeting for inviting me to be part of it. Despite my lack of representation of a Commonwealth country, I will be speaking as an independent expert of the UN Special Rapporteur on the Independence of Judges and Lawyers. As we know, 2024 was the biggest election year in history. On the surface, a landmark for democracy, in which nearly half the world's population was called upon to vote. Democratic participation in political life is an essential human right, which is enshrined in both the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights. We often hear about political disagreement, disenfranchisement, and apathy regarding electoral processes. This is only part of the story. In all countries and regions, people have also demonstrated their continued passion and commitment to voting and to ensuring that their voices count. But meaningful democracy requires more than free and fair elections. Civic space must be protected. People must be able to exchange information and express their opinions regarding their political representatives throughout the election cycle and beyond. They must also have the freedom to associate, form their own political parties and civil society organizations, and to assemble to voice criticism and dissent through peaceful protest. Meaningful democracy also requires respect for the rule of law. Everyone, including politicians and government actors, must be governed by the same laws. Those laws must be consistent with international human rights standards and enforced equally and without discrimination with respect to all in society. Adherence to the rule of law ensures, among other things, that state action is legal, constitutional, and compliant with international human rights law, and that governments do not exceed the power vested in them by the people. Realization of this principle generally involves the separation of state powers into distinct branches, with the judiciary serving to ensure actions taken by the executive and legislative branches do not exceed the limits of the law. Historically, attacks on democratic governments often took the form of violent revolutions or coups d'etat, but increasingly would-be authoritarians exhibit more subtle conduct that nevertheless has the effect of eroding or subverting democracy. In this model, leaders who come to power through legitimate elections later wield that power to undermine or eliminate democratic institutions and rights. In a terrible irony, they make use of the democratic institutions to further this process of autocratization. Even leaders who are not elected may use similar techniques to evade controls on their actions and increase their grip on power. Regrettably, evidence suggests this is a widespread trend, with research demonstrating that key indicators of meaningful democracy are in decline across the globe. In many states, attacks on democracy have justice systems and justice actors as their target. On the other hand, the existence of strong, independent judicial systems can be a valuable bulwark against autocratizing and anti-democratic forces. Today, I will briefly address two issues: the reasons why judicial independence is important to maintaining meaningful democracy, and the challenges judges face when they attempt to play their role in protecting democracy. First, why do independent judges matter to meaningful democracy? Because it is impossible to guarantee the rule of law without judicial independence. Judges hear claims that state authorities have acted improperly or unlawfully, and in many countries have the power to evaluate the constitutionality of laws and executive acts, and to strike them down if they exceed such bounds. In many states, judges also play a critical role in ensuring free and fair elections, in adjudicating disputes on the lawfulness of electoral proceedings, from voting district boundaries and candidate eligibility to campaign finance rules and electoral procedures and accessibility. In some systems, such disputes are heard in specialized electoral tribunals, while in others they are heard by ordinary courts. If judges are not independent, they may struggle to apply the law equally to powerful political actors or to uphold democratic rights in the face of government pressure. Recognizing the importance of these activities, international human rights law requires states to guarantee judicial independence. Article 14 of the International Covenant on Civil and Political Rights provides that every person has the right to be heard by an independent and impartial tribunal established by law in the determination of any criminal charge against them, or of their rights and obligations in a suit at law. To be independent, courts and judges must be insulated from political interference. But in practice, judges face mounting interference on both an individual and an institutional level. This brings me to my second topic. In what ways are independent judges facing threats in the context of contemporary challenges to democracy? In my position, I have seen that recent threats to judicial independence can be grouped into 4 different categories: attempts to capture and curb judicial institutions, and efforts to instrumentalize and weaponize the law against independent judicial operators. Capture involves legal reforms that decrease judicial independence and increase political control or influence, which reduces the ability of judges and courts to act as an effective check on government power. These reforms are often focused on increasing the influence of the executive or the legislature over judicial selection and appointment, with the hope of engineering the appointment of loyal judges who will favor political actors. Another tactic involves creating new judicial vacancies, either by expanding courts or removing existing judges, including by impeaching sitting judges, purporting to alter judicial term limits, or lowering the age of compulsory retirement. If capture reduces judicial independence by increasing political influence over the judiciary, curbing uses legal reform to reduce the power of independent judges and courts. Such curbing risks negating or dramatically reducing the capacity of judges to uphold the rule of law. Examples of such reforms include removing or restricting courts' jurisdiction to review particular laws, limiting judicial oversight in certain politically sensitive cases, such as those involving national security, authorizing political branches of government to override judicial decisions, or mandating weaker standards of judicial review in some or all cases. Independent judges may also see their capacity to act as an effective check on government power undermined through significant resource reductions or workload increases. In relation to both capture and curbing, some may argue that the values of democracy and self-determination mean elected governments have a legitimate interest in reforming their justice systems and courts. This is, of course, correct. However, international standards provide clear guidance on the acceptable parameters of such reforms. Reform of the justice system must not be used to undermine the independence and impartiality of judges or the ability of courts to check abuses of power. If the first two categories of threat could, in some instances, be promoted by political leaders as neutral reforms to the judiciary, the same is not true for the final two categories. First, let me discuss instrumentalization and then weaponization. Both of these categories involve the targeting of individual justice operators, especially independent judges, for their work to uphold the rule of law and hold government officials to account, or for their perceived association with opposition figures or pro-democracy ideals. Instrumentalization entails the misuse of existing legal institutions, procedures, or laws to exert undue political influence on judicial actors. Disciplinary proceedings may be abused, and sanctions, including suspension or even removal, imposed on individual judges in reprisal for upholding the rule of law. Judges have been removed from office for imposing convictions in political corruption cases or for challenging corruption in international courts. In some instances, removal has occurred without due process. Conditions of service may also be instrumentalized in order to influence judicial conduct or to punish particular judges who have fallen out of favor with government. Judges may experience the withdrawal of their security protection or unwanted transfer to locations viewed as under-resourced, dangerous, or otherwise undesirable. Most damagingly, judges and prosecutors who are perceived as threatening to state authorities may themselves become the subject of criminal prosecution by captured justice actors. Indeed, criminal prosecutions have been used to target justice actors who handled cases concerning public corruption or government violations of human rights, thereby discouraging judges and prosecutors from holding the state accountable to law. Judges and prosecutors who have been involved in such cases may see their immunity protections rescinded, allowing charges to be brought pertaining to their professional work. Alternatively, judges may face criminal charges that seem to be unrelated to their professional work, but which are motivated by political ends. At times, these criminal prosecutions can end in conviction and punishment. Criminalization demonstrates that judges who are assigned the role of upholding a fair legal system are personally vulnerable to punishment for carrying out their professional responsibilities. Such actions hijack the prosecutorial function, transforming it into a tool of repression. The final category of threats to judicial independence that I will address is weaponization. While instrumentalization masquerades as lawful action, weaponization represents an extreme form of threat against independent justice operators involving facially improper acts. Public disparagement of judges by government officials is often used to interfere with judicial independence and to sow disdain among the public. Such disparagement is often of a personal, even lurid nature, with women judges especially vulnerable to gendered defamation and abuse. Judges may also be subject to often relentless online harassment. Judges have been arbitrarily detained and subject to temporary disappearance in some places, when their actions displeased other branches of the state. And most shockingly, judges are sometimes subjected to physical attack. Sometimes such attacks are carried out by non-state actors who act at the behest of or with the acquiescence of government powers. The targeting of individual judges may serve as punishment, retribution, or warning for their work to challenge the legality of government action or to uphold fundamental human rights. As a result, other judges may experience a chilling or deterrent effect, which is likely to influence the context of their decisions, reduce judicial independence, and can diminish the rule of law. Given the severity of the threats faced by judges, coupled with the essential role played by independent judges in upholding democracy, it is vital that action is taken to protect and uphold judges as a matter of great urgency. I commend all of you who are here today. We are here because we believe that the defense of judicial independence is a responsibility for all, and we have extended our support to each other across borders. Let those of us who are here who are not judges take our place beside those of you who wear the judicial robe. We must all speak out when judges' role is at risk, because it is all of our rights that hang in the balance. Thank you.
There is a constant tension in the relationship between the courts and the other branches of the state. A tension that stems from the different views of the branches, the different roles of the branches. The role of the judiciary, as has been stated, is to review the actions of the other branches and evaluate whether they are acting lawfully. This role naturally meets with opposition from the other branches, particularly when the judiciary, through its ruling, frustrates political goals the other branches pursue. In such circumstances, many argue that an unelected body that is not accountable to the people should not be able to frustrate the will of the people. The more cherished the violated act is to the hearts of the political authorities, the greater the criticism, amplified across forms of media. The court has limited access to such media. As a result, the tension between it and the other branches increases. It reaches its peak when the other branches try to use their powers to change the composition or jurisdiction of the courts. This is an observation from a former Chief Justice writing on tension among the branches. My view of the modern understanding of the separation of powers based on the trinity of branches where no branch has total power, goes beyond pay-per-view of the Latimer House principles on the three branches of government. My perspective is largely shaped by first-hand work experience in each of the three branches over a relatively short period spanning almost 3 decades. My time on the bench for almost a decade was in the lower courts, where I presided in all of the limited jurisdictions of those courts, and from time to time exercised unlimited jurisdictions with the consent of the parties before me in civil cases when their wait for a trial date in the higher courts would be longer than desired by those parties. I do not, ladies and gentlemen, naively claim that my view reflects an absolute approach or the truth. I speak for myself, even though from time to time I try to influence the approach of my colleagues. But having said that, the overriding perspective that I have emerged with on the importance of the principle of separation of powers highlights the very connection between the branches and the limitations they play or place on each other. Separation of powers is the backbone of a democracy. However, the foundation of democracy is a legislature elected freely and periodically by the people. Without majority rule, as reflected in the power of the legislature, there is no democracy. Judges, lawyers, and legal scholars often seem to forget this fundamental principle. Focus is usually mainly on the judiciary while neglecting the legislature. The principle of democracy demands that the substantive decisions regarding the policy of the state and the needs of society must be made by its popularly elected representatives. Even though the conduct of some parliamentarians leaves much to be desired, I am firmly of the view that undermining the legislature undermines democracy. I, however, share the view, Professor Margaret, that meaningful democracy is more than just free and fair elections. I believe that a proper appreciation of the judicial role is equally important, and I think both of the Chief Justices underscored that point in their presentations. Whether expressly mentioned or merely implied, it is a central component of any democratic constitution, judicial independence, that is. Among other things, it means building a protective wall around the individual judge that will guard against the possibility of influencing decisions by influencing the conditions of her employment. Now, within the Commonwealth of Nations, democratic countries differ from one another. What is good and proper for one may not be good and proper for another. Ultimately, the democratic nature of a regime shapes the role of all branches of the state. Now, I share the view that there is tension between the judicial branch and the other branches. And I know Chief Justice Mamoun spoke to that tension in her presentation. Now, this tension, to my mind, is both natural and desirable. If the court's rulings were always satisfactory to the other branches, it would raise suspicion that the court was not properly fulfilling its role in the democracy. Here again, my perspective is a function of place and time, relative and incomplete, influenced by the environment in which I operate. But in addition to the constant tension, I believe there is also constant dialogue between the independent judiciary and the Parliament. This dialogue does not take place at meetings between judges and legislators. Instead, it takes place when each carries out its constitutional role. The legislative function is the primary responsibility of Parliament as the elected body representing the people. Enacted statutes are subject to judicial interpretation for their meaning and judicial review for their constitutionality. If the judiciary determines that a statute is unconstitutional, the matter returns to the legislature. The legislature may enact a new statute to achieve the same fundamental purpose as the violated statute, while adopting more proportionate means. The legislature may also, where feasible and appropriate, amend the Constitution and then reenact the statute. Of course, a new statute is also subject to judicial review, and the process can continue. In this dialogue, the legislature usually enjoys considerable latitude, a wide margin of appreciation. But ladies and gentlemen, a similar dialogue occurs when the judiciary interprets a statute in a way that is unacceptable to the legislature. The legislature may enact a new statute or amend the original one to better achieve its goal. The cycle of interpretation and amendment can then repeat. Such amendment is not improper. It does not constitute a forbidden intervention on the legislature into the judicial sphere, provided, of course, that the new law does not retroactively apply to the original case decided by the court. The new legislation does not interpret the older statute. Instead, it creates a fresh normative reality reflecting the will of the legislature. Enacting a new statute in these circumstances is a right and power of the legislature. It does not constitute disrespect of the judiciary. And I say this because I operate in a space where I often hear that comment being made. But on the contrary, it is a healthy practice that properly expresses the dialogue between the branches as partners in the lawmaking business. Among the benefits of this dialogue is enrichment of public debate, because what happens is that issues are placed on the public and legislative agenda, and without adjudication, they may otherwise remain within the confines of the executive branch. However, sometimes when a court makes a decision, someone feels personally hurt by that decisions. Sometimes a judgment detracts from the realization of a political agenda, and the response is an unfortunate loss of temper, which breaks down communication. Some reasons are institutional misunderstandings regarding the judicial role and regarding the appropriate dialogue between the judicial and other branches. And I do agree with you, Sue, that greater understanding of the role of each branch remains work in progress. But we live in a global age, and globalization exposes us to ideals and thoughts that transcend national boundaries and legal systems. Strong trend towards the constitutionalization of democratic politics see people increasingly turning to the judiciary, hoping it can solve pressing social problems. And then the question arises, what is the proper role of the judge? Is the role of the judge simply to decide the dispute before her, to determine the law by which the dispute before her should be decided, to decide cases according to the law of the jurisdiction's legal system? Or is there a role beyond merely deciding the dispute according to the law? It is true to say that judges also create law in their interpretation of legal text. The meaning of the law before and after a judicial decision is not the same. Before the ruling, there were in hard cases several possible solutions. After the ruling, the law is what the ruling says it is. The meaning has changed. New law has been created. And so the issue of establishing criteria for judging judges has become particularly important in view of the frequent attempts to dress up political problems in legal garb and placing them before the court. And so another question arises: how ought judges deal with political problems that have taken on a legal character and in which disappointment may result from rulings? These problems do not usually arise in the easy case in which there is only one answer to the legal problem and the judge has no choice but to choose it. They arise in hard cases in which the legal problem has more than one legal answer. The power to choose, judicial discretion that is never absolute. It is always subject to procedural limitations such as fairness and substantive limitations, reasonability, coherency, consistency, rationality, etc. But at the end of the day, the real issue is, has the separation of powers become blurred? Some claim that in recent years the gap has widened between the practices and public expectations of democratic courts on the one hand and the intellectual normative principles that are supposed to guide the courts on the other hand. The danger in the gap is the likelihood of undermining public confidence in judges. So my view as a practicing politician is that when tension between the branches leads to a deterioration in their relationship, monologue replaces dialogue, and that is never a good thing. Power replaces discretion, and for one reason or the other, the rules of the game are broken. Never a good thing. Breaking the rules of the game crosses the red line and is likely to take many forms. And Margaret, you referred to the many forms that the breaking of the rules may take, and I think you framed it as capturing and curbing. But what we have seen cover wild and unrestrained criticism of judgments, attack on the very legitimacy of the judicial decision, recommendations to narrow the court's jurisdiction, threats to create new courts in order to overcome undesirable judgments, attempts to increase the political influence on judicial appointments and promotions, calling for prosecution of judges, demands to terminate appointments or to impeach judges. Just a list from the menu that I have seen scanning the Commonwealth. All these, in the end, lead to the breakdown of the relationship. And then this is the beginning of the end of democracy, or as some say, the backsliding of democracy. What should the judge do when the line is crossed? I'm of the view that the judge must be aware of what is going on around her and not surrender to the ill winds. At the foundation of this approach and my perspective is the view that the court does not fight for its own power, but for the protection of the Constitution and its values. In the parliamentary cabinet system, the executive is largely or almost exclusively drawn from the legislature. The head of government is therefore a legislator. And my view is that the legislature is the senior partner in the lawmaking business. Our offices are bigger than us as individuals. More time needs to be spent to foster greater understanding of the respective roles of the branches. And I believe here in the CLA, it's an excellent opportunity because the legal profession is a feeding ground for political candidates. And so I close, as I did in the related session on the proper relationship between the judiciary and the parliament yesterday. In democracies, the elected legislature, the executive, and the courts all have their role to play. Each must play that role in a spirit of profound respect for the other. We, ladies and gentlemen, are not adversaries. We are all in the justice business together. I thank you.
Thank you very much. Interesting. I think the themes coming out of that, we're going to open. We've got roving mics for questions and observations. We've got a little time for that. We'll probably run a little over time if the organisers don't mind, since we started a little late. Themes I get out of that, I think, are, one is democracy is both fragile and strong, but it does rely on consensus, it does rely on dialogue, and it relies on mutual respect. I have a point I wanted to raise, and before this discussion between the panel, and I think on your mics, if you press the right button, I think that's it. Yeah, it seems that whilst there's a dynamic, there's an increasing friction between the world of politics and the judiciary, and in particular, I wonder about two things. First of all is that certainly in our jurisdiction, we've seen a huge growth in judicial review over the years. That growth has largely been fed, I think, the largest part of our judicial review system is housing and immigration. And that has potential friction in which judges have been said to enter into political views, expressing their political views and their background. Secondly is that we're seeing increasing influence, I think, of international rights in which judges look towards, as we talked about, the sort of globalization of justice, the rights of the child, convention rights, particularly now in climate justice. And I wonder if that's having an influence in developing that friction. Finally, I ask a question also is, does it make a difference if the executive has some control over Parliament, has some over the Houses? We've got, in the UK, obviously, we've got a huge majority for Labour, and I wouldn't say this of the government, but there is a potential, obviously, for misuse of that power by an executive. And in the States, we have an executive with supporting houses for the time being in the Republican Party. And I just wonder if that's a potential area where the role of the judge becomes stronger where the executive, and we saw it in, I think, in the Miller case, the two Miller cases, this friction between the executive and Parliament. And I just wonder if those issues, whilst you're commenting otherwise on the other speakers, whether you might just address those. We'd like to. Yes, sir.
Press that? Yeah. Thank you. I have to say I enjoyed each of your speeches enormously, and I'm going to take away, amongst many other things, Margaret's 4 methods, which has really made me think, and I think curbing and weaponizing is certainly something that we have been thinking about. I think, David, you're absolutely right. We are seeing increasing friction. I think, as Marlene says, totally agree that we need dialogue, not monologue, when these frictions arise. I think there are many, many reasons for this, including, for example, the rise of social media and also the rise of various political parties. But I totally agree with you. If I can just focus on judicial review, particularly in housing and immigration, because I think it ties in very neatly with one of the points that you made, Marlene, is that increasingly judges are being asked to rule on matters of law arising out of intensely political areas for debate. And not only are those decisions by their nature likely to be difficult, they're likely to be controversial because it is almost impossible to envisage a situation where there is only one right answer. So an enormous amount of scope for debate. But I would emphasize that in the middle of this friction, it is really important that we remain mutually respectful and that we engage so we understand and we communicate. I spoke a lot about misinformation and lack of understanding. We were discussing this earlier this morning. We judges can go the extra mile, as I think increasingly we do, to enhance public understanding of often very complicated issues, whether it's through press summaries or shorter judgments. I think that's really important, but I harbour a lingering concern that at the end of the day there will always be people who don't want to understand, or even if they do understand, they want to misinform. So there's a limit to how far we can do. But I think that how to deal with this increasing friction, which I agree exists, is a really important topic of debate. Respect, understanding, good communication, I think, lies at the heart of beginning to solve some of these issues.
I don't have nothing more to add. Thank you.
Using examples from my jurisdiction in Jamaica, I think how parties conduct themselves go a long way in either undermining or restoring confidence in the institutions. So sometimes when political disputes arise in the parliament, one side will say to the other, I'm taking the matter to the court. And the impression is given that the court will somehow make a decision that is favorable on political terms instead of deciding on the merits. And then we also have unfortunate cases where comments are made not only by members of the political directorate who experience frustrations when their political agenda gets disrupted, but judges often, and I say often because of what exists in some cases, they themselves make comments that are entirely unhelpful. And I'm not talking about just comments in judgments, comments in the course of hearing matters, and sometimes appear too relaxed and too overtaken by the cordiality of the parties and make comments that are then reported by people in the court or are, you know, in this age of information and communication and social media. And it makes the quarrel bigger and it makes the tension bigger. So a lot of care has to be taken because the truth is that we cannot afford to have our courts undermined. I know from the parliament and from the executive that it will do us no good. And at the same time, it's important for parliamentarians to understand that as the senior partner, you really don't have the luxury of losing your temper. Not in a way that will undermine the institutions when you are part of the leadership of your country. And the voting population will take their cue from you. And I think that is where it becomes extremely dangerous, because you go through perhaps the most difficult job interview to get into office, running an election, and you have a host of followers behind you. And if you say yea, they will say yea. If you say nay, they say nay, with no rhyme or reason. So great care has to be taken.
David, could I come back to you? I'm
Yes,
conscious we haven't addressed the second question, which is, does it make a difference if the executive control over Parliament is one with a huge majority? I wonder what you think about the answer to that. As a matter of principle, I don't know what the answer is in practical terms, but standing back as a matter of principle, one might say the bigger your majority, the easier it is for you to do the right thing. As a matter of principle, but I don't know whether you agree with that, David.
I'll leave it on that theme. Yes, absolutely. Right, we've got some.
Just say though that sometimes when you have a large majority in the Parliament, it is a lot more difficult. It's not always easier.
Yes, I think that's absolutely right. It's not as straightforward as you say. The opposition comes from within your own party, I think, in those circumstances. Yes, please. We've got a question. We've got some questions from the floor. Is that working? Doesn't sound like it is.
Yeah, Satvinder Jas, 3 High Court Chambers, London. Marlene thoughtfully raises the question as to what the proper role of the judges should be. And of course, David Green has also referred to the expansion of judicial powers in relation to housing and immigration. Traditionally, the judiciary has been the weakest component in the Constitution. Across the world, as Margaret Satterthwaite pointed out, we've seen bumper elections last year, so that the executive now stands emboldened as never before, with the legislature unable to restrain it. I recall the 1976, 2 generations ago, Richard Dimbleby lecture, where Lord Hailsham referred to the dangers of elective dictatorship. And I wonder whether outside the areas of housing and immigration, the time is now right for a more emboldened, muscular, and activist judiciary, particularly in the kinds of cases like Jinnah Miller and the unlawful prorogation of Parliament in the protection of the Constitution, whether it be written or unwritten.
Who's got to? Anyone going to respond?
Okay. We had a very interesting debate yesterday. What do you mean by activist judges? If we mean politically active, in my jurisdiction, we don't have politically active judges, so we don't have activist judges. If we mean activist judges in the sense of liberally interpreting laws, that may be something different. I think it's a very interesting question. I think we have to be very cautious. I think one of the really important themes from today and yesterday and this week as a whole is the power in this room. Judges have to be very careful for constitutional reasons and all sorts of reasons, speaking through their judgments and then through well-established channels of communication. I think that it's important for us to stand together, and I think that the power in this room to protect the values that we all cherish is immense, and I think that's an important thing to recognise. I recognise I'm slightly dodging the question. That's only because it's a very good one.
Margaret, yeah.
I'd like to say that I think the Chief Justice's dodging is highly appropriate. And I think it really is to the bar to support judges and also to, I think, interpret and explain what judges are doing and sometimes to explain why they're not being activists. I think this is very, very important. And because of that discretion and that moderation that judges must show, it falls on lawyers, I think, in the bar to explain the role of the judiciary and to defend them when they're under attack.
Yes, there's a question here, and I see one here.
Thank you. My name is J.S. Okutepa, SAN from Nigeria. I wish, my observation is I wish that some other country other than advanced country in Commonwealth were part of this discussion. I speak particularly of countries from Africa, particularly my country, Nigeria. My question is, first, what do we do about state capture of judiciary? What effect does it have on independent judiciary, particularly in process of recruitment? My Lord, the Honorable the Chief Justice of Malaysia talked about in Malaysia, appointment is done, not election. The same thing in Nigeria. You now see judicial timidity that has affected the independence of the judiciary and principles of law that are anti-justice. You have judgments that are completely devoid of justice, particularly in electoral jurisprudence, where judges put roadblocks in the principles of law that have affected the sovereignty of the people. I wish that we have opportunity to discuss this issue, particularly in my country where people exercise their franchise, but the politicians decide to take away that result from the people, and the law allows you to go to seek remedy from judiciary. And the judiciary itself, rather than seeing the pain of the people, begins to put roadblock on the attainment of justice. For instance, there's a principle of law in my country now that when you are subpoenaing a witness to testify for you in electoral matter, you must front-load the witness statement on oath along with the election petition within 21 days. That to me is very difficult to do as a lawyer. So when you talk about independence, judicial independence and parliamentary sovereignty, do we talk about the independence of judiciary? Because in my state, for instance, in Nigeria, there appears to be conspiracy between the parliament and the executive, and even to a larger extent the judiciary, to undermine the independence of the judiciary. What do we do about that? When a situation where the judiciary itself is not ready to be independent.
Forgive me, I'm conscious of time, and we want to try and fit in as many questions as possible. Does anyone want to comment on that? I mean, I might just before Chief Justice I might say is that the great thing about the CLA and this conference is the sort of bringing together of the judiciary from across the Commonwealth. It is a fantastic institution, if I may say so, for bringing together the judiciary and politicians and practitioners across the Commonwealth, so that all nations might not be represented up on here, but they're certainly represented in this conference, and it's a great time to have a debate. Yes, Chief Justice, sorry.
Well, I don't have an answer to what do we do when, there's conspiracy between the executive, legislature, and even the judiciary itself. But to me, when we talk about judicial independence, it comprises of institutional independence and also individual independence of the judges. So, and this is where the significance of the appointment process comes into play, because how do we ensure that judges who are elected to office are truly someone who, who would uphold the rule of law and who has integrity, impeccable integrity. The appointment, or rather the selection process, must be transparent. It must meet the criteria or the requirements that are stipulated under the law, because if we follow that selection criteria, then I think we'll be good. But if there is some interference by external factors, whether it be from politicians or anybody else, then the selection criteria would be blurred. We don't know what are the factors, or rather, the criteria that this particular candidate has met, or what would be the reason that this particular candidate is being appointed by the executive, particularly in cases where there is interference in the judicial appointments. So the answer would lie, what do we do? I think we have to go back to the selection process of the judges itself. Thank you.
Yes, can I take one here? Yes. We've got time for about 2 more questions, depending how quick they are.
Yes, good morning. I'm Andrew McRae. I'm Vice President of the Court of Appeal in Hong Kong. And I have a question and a comment. Sometimes, we all know, judges and judgments are in receipt of unfair or ill-informed criticism, inflammatory or vituperative comment, and politically motivated accusations. When that happens, how does the judiciary respond? Does it say nothing and rise above it and rely on right-thinking people to see through the fog of criticism and contumely, or hope that the problem will go away? Or does it react in some way and fight back? And if it does, how does it do so? Who should do it? And how far should they go? That's my question. And that leads me to my comment. I come from a jurisdiction where judges are under threat of sanction from the United States. Now, I don't know whether anybody fully understands the complexities of what it is to be sanctioned, but in effect, in practical terms, it means a limitation on your travel movements, and it means no bank account for the rest of your life. And if you can imagine going out for lunch today and you don't have access to a credit card, what life would be like. Now, I want to make it clear, as a judge, as a senior judge from Hong Kong, that neither I nor any of my colleagues in Hong Kong, which is has an independent judiciary, have ever been at the receiving end of being told what to do or how to do it. And the idea of conjuring up a telephone call from Beijing just before I'm supposed to decide a particular case is frankly laughable. And yet, that is a common perception that seems to have gained currency around the world. The threat of sanctions in Hong Kong against Hong Kong judges has had and continues to have a particular effect on the recruitment of judges and the perception of judicial independence. You will all have heard of the Court of Final Appeal and our difficulties with judges being recruited to that body. So far as the United Kingdom is concerned, we've managed to retain Lord Neuberger and Lord Hoffman, but the latter has just turned 90, and we are having significant difficulty in recruiting judges to what is an august and independent body. So I wonder, as a Commonwealth body, what we can do, or what we should do, and what perhaps individual countries can do to foster what is an independent judiciary in Hong Kong and the rule of law in Hong Kong. I would encourage, and I've been asked by the Chief Justice of Hong Kong to encourage anybody to come to Hong Kong and see for yourselves what it is like and how the judiciary functions. And I suspect you will be amazed that it is rather different from a lot of what appears in the press. But nevertheless, I would encourage this body to assist as far as it can the people of Hong Kong and its judiciary. As Professor Satterthwaite said, when judges are threatened, we must all speak out, because it's all our rights that hang in the balance. So that is my comment, but it derives from the question that I posed.
Thank you very much. Before we come to answer that question, I'm going to look and see if it's quite difficult to see anything from up here. But is there one? Oh, there's a further question. We'll take a further question, and then I think if we might respond and then give some closing remarks and finish a little late, but appropriately, I think.
Hi, I'm Saurabh Singh. I'm a high school student from India. And my question is directed primarily towards Madam Minister Malahoo and Baroness Carr. With regards to states with declining democratic indices or even majoritarian tendencies, particularly those who that practice a doctrine of parliamentary supremacy, what measures can be taken to empower the judiciary in upholding human rights as recognized by the Commonwealth and the UN? And also, in light of undemocratic legislation that is passed. To append my question with historical instances of this happening, we can look at Sri Lanka before the Civil War, where Buddhism was made the state religion and the Tamil minority was deprived of many economic rights. And also, of course, the Enabling Act of 1933 passed by the Weimar Parliament, enabling Hitler.
Thank you. Thank you very much. Should we try and respond to those? It's very difficult to respond to specific circumstances, but I wonder also we might have some closing remarks. I'm going to start with politician at the end there, Marlene. Yes.
I've just been thinking that we have so many examples of development being thwarted and people's lives people being left behind when you have wicked rulers in place. And as I look in my own jurisdiction, where people look to us to do right by them and to make better decisions by them, just how important it is for everyone to be part of the democratic process. I find that in the face of apathy and cynicism, many opt out, not realizing that whether you participate or not, decisions will be taken and people will be elected to office. And so, notwithstanding the very difficult state in which the world finds itself, all right-thinking members of the society need to play their part, stand up and be counted. Because Lord knows, if we know better and do not do better, we are worse off than those that we criticize. So all is not lost. In the context of the CLC, here is a body of lawyers across the Commonwealth. We meet periodically to exchange views on important matters. And I invite you to go away thinking, but as you think, do not just step in your usual place of comfort. Go beyond and find the courage to do what is required to help someone else. So whether it's the call for assistance out of Hong Kong or anywhere else, I think as a community we have a duty to stand up when it counts. And I'm counting on you, and hopefully you can count on me to do my little part where I am.
Yes, Margaret.
I will just address the specific question about when judges should speak out. First, I think judges are the ones to make that decision, but I will comment that certainly a number of bodies have underscored that judges do, of course, have freedom of expression, and that in circumstances where judicial independence is under attack, they may even have a duty to speak out when it comes down to the difficult circumstances. And certainly the European Court of Human Rights has said this, that there comes a time when it is important for judges themselves to speak. But again, to end, I would put the onus on those of us who don't have the duty of discretion, the duty of moderation, and the duty of remaining outside of political debate. Those of us who are lawyers can speak out at any moment and must.
Chief Justice Maynard.
Thank you. If I could just respond to the point raised on the whether when judges are under attack, whether we respond at all. I would like to give 3 instances, as what we had experienced in Malaysia. But generally, before I enlighten you or share with you the specific instances, let me just say this. In Malaysia, we do not generally respond to whatever statements or attacks made against judges. And in this regard, I think I wish to repeat what I said in the 23rd Commonwealth Law Conference in Goa, that when judges or the judiciary are under attack, then we expect the bar and the AGC to come to our aid in that sense. I would like to share 3 instances in Malaysia where the judges and judiciary are under attack, and we did not respond in the sense of making statements or respond in particular to those remarks made. The first attack, if I may say so, arose from a decision that we made in relation to the corruption case against the former Prime Minister. And what happened then was, after the decision was delivered by the apex court, the highest court of the land, and that would be the final court affirming the conviction of the former Prime Minister, the lawyer that was handling the case sort of went on a roadshow throughout the country, and also appeared in a meeting of a political party and make statements criticizing the judgment, and also calling for the dismissal of the judges, including me. So we did not make any response to that. That was the first instance. Because to me, personally, I think that there was no point in making any response. We had made our decision, so whatever explanation or response that we, if at all, we should make, would be of no utility as far as I'm concerned. The second instance was also in relation to that particular case, where an allegation was made against the judge of the court, first instance, where allegation was made that he was, there was a conflict of interest when he heard the matter, and also allegation that he had several amount of monies in his bank account which could not be accounted for. And that was, that allegation was raised by the accused person, rather the convicted person. And unfortunately, the allegation was picked up by the agency, investigative agency, and we had to respond to that particular allegation in a case filed by a lawyer, Haris Fatila. So that response came through our judgment, and we vindicated the judge. And in that sense, that was how we respond to the attack against the judges, against the judge. And the third one would be in relation to another judgment that we delivered, where, as Chief Justice of England and Wales was saying, we prepared our summary for public interest cases and important cases. We normally prepare a summary of our judgment in plain and simple language so that the public can understand. But unfortunately, it's not the public who rather misinterpret or misunderstood the judgment, but it was a politician, and so happened that he was also a practicing lawyer who chose to, well, either he did not actually understand the judgment, or he chose not to understand. So he went around making statements about, how it was a black day when the decision came about. So these are the instances where we did not respond because I personally, as a Chief Justice, do not see the point of responding to all these attacks and allegations. Thank you.
Thank you very much. Anything to add, Sue? No. Okay. Well, we're well past time, actually. Chief Justice of England and Wales, we were talking about the drama of yesterday. We had the opera. I did offer to sing, but...
I'm not going to sing.
I did offer to sing, but you said no.
I definitely said no. Thank you.
Let's end on that theme. So I think what we've seen of this is there is actually a larger sense of agreement between both the political side, the judicial side, and I think practitioners' side. It's consensus, it's dialogue, education, I think we've talked about as being important, and the margin of appreciation. So can I thank our panel for today's contribution? It's a really essential subject. Thank you.